Please be seated.
Yes, Mr. Stolger.
Commissioner, the next witness is Ms Gillard.
Do you solemnly, sincerely and truly declare and affirm that the evidence you shall give in this Royal Commission shall be the truth, the whole truth and nothing but the truth?
I do.
Please have a seat, Ms Gillard.
Thank you.
Your name is Julia Eileen Gillard.
Yes, it is.
You're a resident of South Australia.
That's correct.
Can you tell the Commission your current occupation?
There's a list. I am, of course, a former Prime Minister and do a number of things associated with that. I am an author. I am the chair of the Global Partnership for Education. I am a non-resident Distinguished Senior Fellow at the Brookings Institution in Washington. I'm an honorary professor at the University of Adelaide.
All right. And you've prepared a number of witness statements.
Yes, I have.
Do you have copies of those with you?
I have with me my principal statement and its annexure.
All right. Now, there were also some short statements you prepared dealing with evidence given by Mr James, Mr Spiridis and Mr Hem. I'll provide you with those.
Thank you. Thank you.
Have you given our unsigned versions of those, Joe?
Yes, I think so. Now, Ms Gillard, did you need to make any correction to your longer statement? I think you called it your principal statement.
Commissioner, can I assist with this rather than Ms Gillard having to go through the document at the moment? We just picked up a typographical error at paragraph 26. This is of the principal statement, Commissioner. Yes, I've got that. Thank you, sir. And if you go to the last line, the words from the bank and my salary, the and should be an or. Yes. That's the change, sir.
Save for the correction that Mr Cleland has pointed out, the content of your four statements is true and correct?
Yes, they are.
I'd ask that those statements be received into evidence, Commissioner.
Yes, those four statements will be received into evidence.
Now, Ms Gillard, by way of background, you obtained your law degree in 1986.
Yes, I did.
And you were, at some point thereafter, admitted as a solicitor to the Supreme Court of Victoria.
Yes, I was in 1987.
And in that year you commenced working as a first-year solicitor with Slater and Gordon.
Yes, I did.
You practiced in the industrial area.
Initially, I practiced in the commercial section and in the industrial section, and quite quickly that moved to being full-time in the industrial section.
And you reported to Mr Murphy?
Yes, I did.
And 3 years later, in November 1990, you were made a partner in Slater and Gordon?
That's right.
Salaried partner?
Yes, that's right.
And you kept up a close professional relationship with Mr Murphy?
Mr Murphy was the equity partner in the industrial unit, so yes.
And you had the next door office?
That's correct.
And you became friends?
Yes.
Now, not long after you were made a partner at Slater and Gordon, you or the firm received instructions to act for the Australian Workers' Union?
In either 1989 or 1990, the firm commenced to work for the Victorian branch of the Australian Workers' Union.
Oh, I see. So you may not have become a partner at that point?
I'd have to track the dates, Mr Stolger, but in or around the same time.
Now, who was the person doing most of the work for the AWU? Was it yourself or Mr Murphy?
It was Mr Murphy who was the principal contact with the Victorian branch.
And thereafter the AWU was an important client for the firm?
It was one of a wide range of clients.
The client was the AWU, not any particular individual within the AWU?
The client was the AWU Victorian branch at that point.
Right. And you did work for the AWU yourself?
I did some work, but at that point the Victorian branch was principally Mr Murphy's client for industrial matters. Obviously they would also refer personal injury work to the firm that would be done by a range of solicitors in the plaintiff personal injury practice.
Now, on becoming a salaried partner, your pay arrangements were changed?
Yes, that's right.
And you your salary was nominally increased, but the increase was effected through a loan advanced to you by the firm.
Yes, that's right.
And in substance, the loan comprised a total amount of $40,000,
Yes.
which was paid in two tranches, one in February 1991 and one in June 1991.
I didn't independently recall all those details. I did recall the firm made me a loan for the purchase of the house.
Right.
But Mr Stolger, I've had the opportunity to look at the relevant documents, and what you say is right.
Yes, I think there's something in your statement to that effect.
Yes.
That enabled you to acquire a property at 36 St Phillip Street, Abbotsford.
Yes, it did.
Now you borrowed, I'm sorry to delve into the financial details, but you borrowed $118,000 from CBA to acquire that property. Does that sound right?
It sounds right.
And there's, in addition, some stamp duty, and then you needed also the advance from Slater and Gordon to facilitate that purchase.
So Slater and Gordon assisted with the $40,000, and then I borrowed the balance from the Commonwealth Bank.
So you, in substance, borrowed 100% of the proceeds necessary to acquire the Abbotsford property?
I think there may have been some of my savings in there, but the overwhelming bulk of it was the Slater and Gordon monies, or the monies by way of mortgage from the Commonwealth Bank.
Right. And you were living there from about June 1991, you yourself?
Once it settled, yes.
Now, you met Mr Wilson for the first time in that same year?
Yes, that's correct.
April 91. He was the secretary of the WA branch of the AWU?
Not at that point, Mr Stolger, no.
All right. Can I show you a folder of documents? It's been marked AWU, WRA, Gillard, MFI1. Commissioner, do you have a copy of that?
Yes, I do.
Thank you.
No, this is easy for us, but
It's all
touch it on us.
If there is a spare
Thank you.
Could I take you to... first of all, I'd ask that that folder be received into evidence, Commissioner.
The objection. Anyone who hasn't had a chance to read it will have their rights to object in due course preserved.
We'll reserve our position. Thank you.
Yes, likewise, Commissioner, we didn't know it was this folder.
Yes.
Could I take you to...
It'll be received in evidence.
May it please the Commissioner. Could I take you to tab 3, page 131 in the bottom right-hand corner? That's the transcript of interview that you gave in September 1995 to two of the partners at Slater and Gordon. And if you go to page 132 in the bottom right-hand corner, the transcript reads, I met him in April 1991. You're dealing there with your encounters with Mr Wilson. I met him in April 91. And you say at the bottom of the page, I was asked when I was over there, that's WA, to contact Bruce by Graham Droppett, who was then an employee solicitor of Slater and Gordon. He was from Western Australia. He'd done legal work for Bruce when he'd been in WA. So Mr Droppett had got to know Mr Wilson, had he?
Yes, that's right.
And he introduced Mr Wilson to the firm as a client?
Mr Droppett worked in Western Australia. He was Western Australian. He knew Bruce Wilson. He asked me to meet with Bruce Wilson whilst I was in Western Australia on other legal business.
Right. And then coming down the page, this is page 133, you say he was at that point basically stalking the then WA secretary with a view to getting him out and taking his position, and he needed some legal advice about arrangements to do with that. What did you mean he was stalking the then secretary?
At the time I met Mr Wilson, he had already been involved in the Australian Workers' Union. He was seeking to become Secretary of the Western Australian branch of the AWU.
Well, he was seeking to remove Mr Keenan, is that right?
As I understood it, there was disputation within the branch. including about the performance of the then Secretary.
Do you recollect what the legal advice was that you gave to Mr Wilson at the time about those matters?
No, I don't recall.
Now, you say that you stayed on, I'm just continuing to travel through page 133, you stayed on in Perth for the purpose of meeting with him, and then you say you became involved in a personal relationship with him in effect, 1991, or late 1991. And that's all accurately summarises the course of events, I take it?
Yes, that's right.
Then you mention further down the page that when Bruce came to Victoria, he came alone. This is again on 133, and he was subsequently joined by an organiser from Western Australia known as Bill Telecostaglou, or simply Bill the Greek. Now, do you recollect what his role was at the AWU that's Mr Telecostaglou, when he came to Victoria?
He was an organiser, I believe.
Did he report to Mr Wilson?
Mr Wilson was acting secretary and then subsequently became secretary of the Victorian branch of the AWU. So all organisers would have reported to him. Mr
Telecostaglou has been described in some documents as Mr Wilson's minder. Is that a fair description?
I wouldn't use those words, no.
He carried out a wide variety of work at the direction of Mr Wilson?
I don't have a particular view about what work he carried out at the direction of Mr Wilson. I understood him to be an organiser.
When did you first hear of the Workplace Reform Association?
As is detailed in my statement, in 1992, I received instructions from Mr Wilson about providing legal advice on the incorporation of an association.
When you say in your statement, you mean Witness Statement 4 that's now become part of the evidence in this commission?
Yes, that's right.
You're not referring to your exit interview with Slater and Gordon?
I think the matter is dealt with in both. I presume by exit interview you're referring to the transcript of the meeting.
Yes.
On the 11th of September 1995.
Yes, I'll just call it the interview. But in any event, you say that in paragraph 13 of your statement that you provided advice to Wilson and Blewett in relation to the setting up of an incorporated association. And now that was sometime prior to April 1992, was it?
Yes, that's correct.
Did you have any discussions with Mr Wilson about that when he was stalking the WA Secretary?
No.
So that came up after he'd moved to Melbourne?
It came up in 1992, not 1991.
Right. So Mr Wilson raised it with you?
Mr Wilson raised with me wanting to have a fund in Western Australia that would support him and his team and their re-election in Western Australia, and regularising arrangements amongst the team.
Well, if you could come to page 134 in the bottom right-hand corner, you're dealing with this sequence of events.
What's the page of the document? We don't have the folder yet.
Page 4.
Page 4 at the top.
Thank you, Commissioner.
You say now, Mr Gordon says now around about mid-1992, were you asked by Bruce or Ralph or anyone connected with the AWU to set up certain incorporated associations to enable the union or factions within it to raise and control funds? And you say yes. And then you give some more detail about that a bit further down the page. You say, I was asked by Bruce about the holding of election fund monies. It's common practice, indeed, every union has what it refers to as a re-election fund, slush fund, whatever, which is the funds the leadership team, into which the leadership team puts money so they can finance their next election campaign. So is it the position that Mr Wilson wished to have an account of that kind?
The position is as detailed in my statement, my principal statement, that prior to April 1992, I was asked by Mr Wilson about the holding of election monies for the support of him and his team in Western Australia, and I provided advice on the incorporation of the association.
You say that's in your statement. Where do I find in your statement reference to his team in Western Australia?
It's not detailed in the statement, but it was about him and the team of officials he would run with.
Well, when did he say that to you?
Well, in these conversations. Obviously, when people run for union elections, they run with a team of supporters.
All right. Now, could we come back to page 134 of the interview? So page 4 at the top, if that's easier. It says, Bruce, about halfway through the long paragraph, Bruce wanted to have such an account. We have at Slater and Gordon, we have incorporated associations for the purposes of holding, if you like, being the legal entity that holds such an account. So had you been involved yourself in setting up incorporated associations of that kind for other unions?
I don't recall setting up any other incorporated associations for other unions, but my understanding at the time, as detailed in this discussion with Mr Gordon and Mr Shaw, was that had been done by the firm.
You say you hadn't yourself set one up?
I don't recall doing so, no.
You'd done one, I'm not... further down the page, you say, I advised Bruce that we had done that in the past for unions. We had incorporated associations.
Yes.
Does that jog your memory that Slater and Gordon had set up incorporated associations for other unions in the past?
As detailed in this discussion with Mr Gordon and Mr Shaw, it was certainly my view at the time that Slater and Gordon had done such work. I understood your question to be, yes. Do I recall specifically personally doing such work?
Yes.
And I don't recall that.
Do you know for which other unions Slater and Gordon had done that work?
Oh, I don't recall that now, all these years later.
All right, but you say at the bottom of 134, I was uncertain whether the laws in Western Australia were akin to the laws in Victoria about the incorporation of associations. I subsequently checked, and my recollection is they had an almost identical act, and I was then instructed to incorporate an association and did so. So you checked the WA Act?
Yes, I would have done so.
And you were familiar already with the Victorian Act?
Yes, I was.
Now, can I take you to 137 in the bottom right-hand corner? That's page 7. Now, Mr Gordon says, all right, well, let's talk about the AW Workplace Reform Association account. That account, as you've said, is an account which was the account belonging to an incorporated association by the same name, which was incorporated by Slater and Gordon on Wilson's instructions following your advice to him, which you described earlier, and you say that's right. And then the question is, that happened in or about mid-92? Answer, that's right. Now, you're talking here about a bank account, correct?
This document, as you would be familiar, Mr Stolger, records a discussion, quite a lengthy discussion about the AWU Workplace Reform Association.
Yes.
I think Mr Gordon might have been using the terminology account because we'd been talking about election funds. I had no knowledge at that time, or knowledge at any time, about the banking arrangements of the Workplace Reform Association.
Well, isn't he saying to you, he says, that account, as you said, is an account which was the account belonging to an incorporated association by the same name which was incorporated by Slater and Gordon at on Wilson's instructions. Now, he's referring to an account quite separate from the association, correct?
When you look across this discussion with Mr Gordon and Mr Shaw, there's a discussion about the Workplace Reform Association. There's a discussion then about bank accounts at the Victorian branch of the AWU. Yes. I think Mr Gordon used the term account following that discussion. I didn't know anything about the banking arrangements of the AWU Workplace Reform Association.
You understood that the association was setting up an account?
I understood
At
that...
the time, I mean.
Yeah, Mr Stolger, I understood that it was the desire of Mr Wilson and others involved in the association to have an association, to be a team that would run together for union elections and to have an account into which they would bank monies that they had fundraised for that purpose, yes.
And the account to which Mr Gordon is making reference on page 137 is that very bank account, is it not?
He's obviously referring to the discussion before, yes. But if your question to me is, and I may be misunderstanding you, Mr Stolger, and if I am, I apologise, but if your discussion to me is, did I have any knowledge of particular accounts operated by the AWU Workplace Reform Association, no, I did not.
Well, I'm not asking if you knew the account number, but the fact is that you knew that it had set up an account and was operating an account under the same name as the association?
I knew at the time that I provided legal advice on the incorporation that there was an intention to set up an account.
Well, you certainly understood as at 11 September that the account had been set up because Mr Gordon makes reference to it and then you say that's right.
Mr Stolger, I'm not sure I can take it further for you than I have. Right. This was a discussion where we talked about the Australian Workers Union Workplace Reform Association, and in other sections of the discussion I make it perfectly clear that I had no knowledge of any of the banking arrangements of the Workplace Reform Association or any knowledge of its accounts.
When do you say you became aware that in fact an account had been set up by the association?
I did not become aware that an account had been set up by the association.
Well, you know as you sit here today that one was set up, I take it?
In time sequence, sorry, because you've just jumped from this discussion in 1995 to the present day.
Yes.
In time sequence, I provided legal advice, as has been discussed here and is in my principal statement. Mm-hmm. I provided legal advice. I then had no further contact with the work of the association or its banking arrangements. Obviously, given the extensive publicity and inquiry into these matters since, I've become aware in the years since that the Australian Workers Union Workplace Reform Association had an account.
If you go back to 137, Mr Gordon... Page 7.
Thank you.
Yes, you've got it. With the... you go on to... Mr Gordon goes on to say that Slater and Gordon had drafted some model rules and the like, submitted those rules to the relevant Western Australian Government authority, letter back, might be a trade union, therefore ineligible for incorporation, and we prepared a response. And then you say, well, he's asking you about dates, and you say, I wouldn't want to be held to those dates without looking at the file, but whatever dates the file shows are the right dates. Now, to which file were you referring?
I'm referring to the file about the incorporation of the Workplace Reform Association.
Did you open a file in relation to that matter?
I had a file, a manila folder with documents in it, which would have been labelled Australian Workers Union Workplace Reform Association or something like that, which would have been held in the filing cabinets that were on the ground floor at Slater and Gordon where the industrial unit worked.
So you collated the documents in a file and put the file in the filing cabinet but didn't open the file on the system. Is that the position?
Yes, that's correct.
Were there any other files in the filing cabinet that weren't open on the system?
Yes.
You accept that if substantive work's done in relation to a matter, it would be appropriate to open a file on the system?
To just explain the context here,
yes.
In the days I worked at Slater and Gordon, which obviously is a very long time ago, it was a much smaller firm than it is now. Its business model at the time was that it was heavily reliant on plaintiff personal injury work. The laws of plaintiff personal injury work were quite different than they are today. The purpose of the industrial unit was to do industrial work for trade union clients and for employees, and obviously to earn fees in doing so. But it was a part of the purpose of having the industrial unit that Slater and Gordon would form bonds with trade unions, so that trade unions would refer their plaintiff personal injury work. As a result, it was common to do work without fees for trade unions and trade union officials.
It may have been common to do some work, but where you're engaging in substantive work of the kind that Mr Gordon describes on the page I just took you to, a file ought to have been opened, correct?
It was always a judgment call about whether or not one would open a file for work that you were not going to charge a fee. There were various arrangements for doing that. You would keep file notes and they may be put on your personal file. So I had a file in the filing cabinet called JEG General for our trade, JEG being my initials. For trade union clients, we had files in the filing cabinet that we would collect file notes on telephone advice and minor matters. So you might have the Municipal Employees Union-General file. Then if you performed work where you put it in a folder, you'd make a judgment call about whether or not that should be opened as a file on the system. Clear dividing line was the dimensions of the work and most certainly whether or not any disbursements were raised.
But this was a substantial job, you accept that?
Oh, no, I don't.
You don't accept that?
No, this would have been a job that took me in total, I don't recall specifically, but I would have said in the order of 3, 4, 5 hours work at most.
It was more substantial than just bits of free work or telephone advices and that sort of thing?
Mr Stolger, I can assure you I did more substantial jobs than this for free for trade unions during my days at Slater and Gordon.
And it really ought to have been open on the system, you accept that?
Look, when I was discussing this matter with Mr Shaw and Mr Gordon in 1995, I indicated to them that with the benefit of hindsight, maybe it would have been better to have opened it on the system. But I did do more substantial free work for trade union clients and trade union officials than this particular job.
If you go to page 151, there's the passage of the transcript of the interview to which you may be making reference.
Page 21.
Thank you, Commissioner. We've now been provided with the
Good.
And about halfway through the page, it's stated this was a more you say this was a more substantial job than that and really ought to have been opened on the system.
Yes, I just referred to that passage.
Yes. Now, was there a Mr Lang working in the office at the time?
Yes, Mr Lang was employed at Slater and Gordon as a solicitor.
Did he have a particular expertise in incorporated associations?
Yes, he did.
The point in any event is that Mr Wilson was the client, so far as you were concerned?
That's correct.
And you say in your statement in the passage to which you made...
Mr Wilson and Mr Blewett.
All right, well, the person who was predominantly in discussions with you was Mr Wilson?
Mr Wilson and Mr Blewett. Obviously, Mr Blewett was playing a role in this incorporation. He's the signatory to the documents.
My question was, the person predominantly communicating with you in relation to this matter was Mr Wilson, is that right?
I had communications with both Mr Wilson and Mr Blewett. I would have had more communications with Mr Wilson, that's correct.
So you accept that Mr Wilson was the person who was predominantly communicating with you in relation to this matter?
Well, I was communicating with both of them, but I was more regularly in contact with Mr Wilson, that's true.
Can I take you back to page 4 of the interview? That's page 134 in the bottom right-hand corner. And you're discussing there again I'm sorry, I've taken this before, but you're discussing the incorporation of the association, and you say that there or elsewhere that you had set up a an incorporated association, or at least you had a set of rules for the Socialist Forum?
Yes, I do say that. I'm a little bit lost in the document, Mr. Stolger. You're on page 4 at...
Yes, I just can't see the... Oh, it might be here, just a minute. Oh, yes, page 137 in the bottom right-hand corner. You were asked if Mr. Lang had anything to do with the model rules.
Okay, so over on page 7137, yes, I'm with you now.
And you respond, I have just in my own personal precedent file a set of rules for Socialist Forum, which is an incorporated association in which I'm personally involved. Tony Lang and I drew those rules some years ago, and I just kept them hanging around as something I cut and paste. And then you say, I don't quite recall how now, but I obtained the model rules under the WA Act, and I must have done the drafting just relying on those two sources. I don't have a recollection of sitting down with Tony or anyone else or any other practitioner and talking through a draft of the rules. So that's how you came to craft the rules for the association, is it? Drawing on the Socialist Forum rules and the, what you call the model rules from the WA Act?
So I would have obtained, as I said in this statement at the time, obtained the model rules. I had the Socialist Forum precedent. I think, Mr. Stolger, I'm right in saying you'll find a reference to another association here, thinking of Emily's List, but I'd been involved in other incorporated associations since I had a couple of precedents in the model rules.
I see. So these weren't incorporated associations which you'd been involved in setting up, but you in fact had some involvement in the operation of those associations, is that right? Oh,
I'd been involved with Mr. Lang in personal capacities in the setting up of the Socialist Forum, which was an incorporated association. I was also involved with Mr. Lang in the setting up of the incorporated association, which is Emily's List, which is a Labor women's organisation.
Was there a written retainer between Slater and Gordon on the one hand and Mr. Wilson and Mr. Blewett on the other in relation to this work?
No, I don't believe there was.
You say in your statement, and go to it if you need it to refresh your memory, at paragraph 13, that you provided advice in relation to the setting up of an association.
Yes, I have that. Then
in the second sentence you say, I was subsequently instructed by them, that is Mr. Wilson and Mr. Blewett, to incorporate an association. So the first step is that you provided advice in relation to setting up an association. When did you provide that advice?
I don't recall a specific date, Mr. Stolger.
Were you in Perth or Sydney? Do you remember that?
I most certainly wouldn't have been in Sydney.
Oh, I'm sorry, in Perth or Melbourne?
I don't recall. I think it's more likely to have been Melbourne.
And do you recollect who else was present, or who was present? Was it the three of you?
I don't have a specific recollection of discussions and meetings. I've got a general recollection of receiving instructions from Mr. Wilson and Mr. Blewett.
Was Mr. Murphy present at any of those discussions, do you recall?
No, he was not.
Was there a meeting in Melbourne attended by all four of you?
No, there was not.
Was there a meeting in Melbourne attended by yourself, Mr. Wilson and Mr. Blewett, at which this matter was discussed?
I think it is most likely that there was a discussion in Melbourne, but I couldn't 100% say it wasn't in Perth, but I think it's more likely it was in Melbourne.
And then you say separately, or at least in the second sentence, I was subsequently instructed by them to incorporate an association. Do you recollect when you received those subsequent instructions?
Oh, I don't recollect a date, no.
Was it shortly after you'd had that initial meeting?
Oh, I couldn't tell you, Mr. Stolger, the amount of time in between the two.
As far as you were concerned, you're providing Mr. Wilson and Mr. Blewett with all such advice in respect of setting up an association as a reasonably competent legal practitioner exercising due care and skill would regard as appropriate?
I was trying to do my best, Mr. Stolger, yes.
So you agree with me that that was what you were endeavouring to do when you gave them advice?
I was obviously trying to give them the benefit of my professional expertise, yes.
Now, could you have a look at tab 2 of the folder.
Tab 2?
Yes. Page 5. In the bottom right-hand corner is the advertisement.
Yes.
And you make some reference to this in your statement. One aspect of setting up an incorporated association is that there be public notification of that incorporation by way of advertisement.
Yes, that must be the case.
And you were aware of that in 1992 when you were providing advice to Mr. Wilson and Mr. Blewett?
If I'd checked the Act and it's a requirement of the Act, then yes, I would have been aware of it.
Well, you did check the WA Act, didn't you?
Yes, I'm agreeing with you. If I checked the Act and if it's in the Act, then I would have been aware of it. I don't have a direct recollection of it, Mr. Stolger, but from the documents it's apparent that there was a requirement for an advertisement.
I've included a copy of the Act in the folder. I'll take it to you. It's behind tab 8. Tab 8?
8.
Yes. And section 6, which is on page 222 in the bottom right-hand corner, provides that an applicant for incorporation must cause an advertisement in the prescribed form to be published once in a newspaper circulating in the area where the association is situated or conducts its affairs. Subsection 2, the advertisement required by subsection 1 must be published not less than 1 month nor more than 3 months before the application for incorporation is made to the Commission. Now you would have been familiar with that requirement when you were advising Mr. Wilson and Mr. Blewett, I take it?
I would have checked the Act.
Yes.
And read it and understood the sense of it, yes.
And the timing is quite specific, not less than 1 month, not more than 3 months before the application is lodged with the Commissioner.
Yes.
It has to be done in advance, in other words.
Yes.
And that provision enables any person who wishes to object to the incorporation of the Act to do so, or at least facilitates that objection being taken.
Yes, I presume so.
I take it that you advised Mr. Wilson or Mr. Blewett in relation to the requirement of running that advertisement?
I don't recall providing that advice.
In all likelihood you did?
Look, I don't recall it, Mr. Stolger. Clearly, from the documents, you can see that an advertisement was placed in the newspaper.
In all likelihood, you gave advice in relation to the necessity to run that advertisement in a particular form and at a particular time.
Well, all I can say, Mr. Stolger, is I don't recall that. It's a long time ago.
No, but my question was, in all likelihood, in the ordinary course of your practice, you gave that advice, correct?
Look, I'm not in a position to help you on it. I don't recall it. I can see from the documents that an advertisement was published. To the best of my recollection, I don't believe I drafted that advertisement.
Well, Mr. Wilson didn't engage any other solicitor, did he?
No, but it is possible that Mr. Wilson or Mr. Blewett drafted that advertisement.
It has a, just looking at the word, it's a little hard to read, but it says notice, the words, notice is hereby given that Ralph Blewett, of a particular address, being duly authorised by the above association, intends to apply to the Commissioner of Corporate Affairs on or after 9 April 1992 for the incorporation of the Australian Workers' Union Workplace Reform Association. That language has a legal flavour, you agree?
Mr. Stolger, I don't know what you're asking me to say. Could someone without a legal degree draft that language? Well, of course they could.
The likelihood is you advised Mr. Wilson of the necessity of placing the public advertisement.
Well, Mr. Stolger, I'm giving evidence in a Royal Commission. I'm not prepared to guess.
And in the course of advising, it is likely that you gave advice as to the content of the advertisement, correct?
Mr. Stolger, I don't recall giving any advice about the advertisement.
The advertisement says that the association is formed for promoting and encouraging workplace reform for workers performing construction and maintenance work. That's my reading of it. Was that the true purpose of the association as you understood it back then?
So I'm just struggling to...
I think it says
to read the
promoting-
bottom, is that what you're saying, the bottom paragraph?
Yes,
that
I think it
advertisement
says the association is formed for the purpose of, I think it's promoting and encouraging workplace reform for workers performing construction and maintenance work.
Oh, Mr Stolger, I don't recall drafting this advertisement. I don't believe I did draft this advertisement, so I'm not in a position really to help you with the meaning of the advertisement.
You understood, setting aside the advertisement, that the purpose of the association was to raise money for the re-election campaigns of Mr Wilson and Mr Blewett?
My understanding of the purpose of the association was that it would formalise arrangements between a team of officials who had an intention of running together at the next election. It would enable them to fundraise to support that re-election campaign.
You say it would formalise the relations between a team of officials, is that what you're saying?
Yes, Mr Stolger, in my discussions with Mr Gordon and Mr Shaw back in September 1995,
Yes.
I explained my view of this association, these kinds of associations,
Yes.
saying that it means that people who are working together in trade union elections turn their mind to questions like what would happen if the team divided,
Oh, yes.
avoid the problems associated with collective monies perhaps ending up in an individual bank account.
Yes, that's at 134. You make reference in about point 8 on the page. The problem developed that when the leadership team fractured, you got into a very difficult dispute.
Sorry, does Ms Gillard have that in front of her?
I do, so you're back under tab
3.
under tab 3. Yes.
You were making reference
134.
to passages of your discussions with Mr Gordon and Mr Shaw, and I'm directing your attention to the particular passage to which you were making reference. And you say that problems develop when the leadership team fractured, as relatively commonly happens, you get into a difficult dispute. So it was better to have an incorporated association, a legal entity into which people could participate as members. That was the holder of the account. Is that what you meant when you said earlier that this would regularise the relations? Now, the operation of the Act is to facilitate the incorporation of associations, correct?
Yes.
You understood that at the time?
Yes.
And the Act isn't something that regulates the creation of associations, does it?
Not sure I understand the distinction you're making, Mr Stolger.
Well, you were a lawyer in 1993, a successful lawyer. That's right.
Yes.
And you understood that there could be associations which were not incorporated.
Oh, yes, I'm with you now, yes. Yes, Mr Stolger, I did.
For example, an association whose objects fall outside the Act for one reason or another.
Yes, Mr Stolger, I understood that there were unincorporated associations.
Or one so small and informal, for example, that there was no need to incorporate it.
Yes, Mr Stolger, I understood that.
So the Act facilitated, and still does facilitate, the incorporations of an association that's already been formed, and for whatever reason, the members or the officers of the association now seek its incorporation, correct?
Yes, that's right.
And there are various criteria stipulated in the Act which are taken into account in determining whether the application for incorporation is to be granted.
Yes, that's correct.
And if we just look briefly at some of those criteria, if I take you back to the Act itself.
So that was tab 7?
Tab 8.
Tab 8.
Begins on page 218. And why don't we begin with section 4. It says, subject to this Act, an association is eligible to be incorporated under this Act if it has more than 5 members and is formed, and then there are a series of purposes described.
Yes, that's right.
And then similarly, we looked a moment ago at the requirements for advertising. Section 6, an applicant for incorporation must cause an advertisement in the prescribed form to be published once in a newspaper circulating in the area where the association is situated or conducts its affairs. So the Act is contemplating an advertisement being placed by an already existent corporation, correct?
Yes, it is.
Well, I'm sorry.
Oh, no, by an applicant. It says an applicant for incorporation.
Yes.
But your point is you could have an unincorporated association that chose to incorporate, and that would be the applicant.
Yes.
Yes.
And then similarly, the rules of the association needed to be in a particular form. So, for example, Section 5 provides an application for the incorporation of an association must be made to the Commissioner in the prescribed manner and form, and then coming over to the next page, application for incorporation must be accompanied by a copy of the rules of the association conforming to the requirements of this Act. And then, likewise, Section 9 requires that the association, upon the application being made, Commissioner forms an opinion the association is eligible to be incorporated and the rules conform to the requirements of the Act. If criteria of that kind are met, then the application for incorporation may be successful. Correct?
Yes, Mr. Stelter.
And upon incorporation, of course, there are great benefits to the members, most particularly limited liability.
There are benefits of incorporation, correct?
Well, the Section 10, as you no doubt recollect, provides that subparagraph C that rights and liabilities exercisable against members or officers of the association become rights and liabilities of and exercisable against the incorporated association. So there's a form of limited liability.
Yes, Mr. Stelter.
And you understood that at the time.
Yes, I did.
It's very different from the incorporation of a company where the company springs into existence upon the registration of the company.
Intellectually, Mr. Stelter, I'm agreeing with you. I was not involved in the practice of incorporating companies when I was a lawyer.
All right. Now, if you go back to the advertisement, which was behind tab 2 on page 5,
Yes.
the drafting of that is consistent with the analysis I was just taking you through, in the sense that it provides, and again, it's not that easy to read, but if I read out what I apprehend to be the words, notice is hereby given that Ralph Blewett, of a particular address, being duly authorised by the above association, intends to apply to the Commissioner on or after a date in April 1992 for the incorporation of that association. So what's being proposed is that at some date in the future, Mr. Blewett, who is duly authorised, would submit an application for that particular association to be incorporated, correct?
That's the meaning of those words, yes.
And at that point...
If they are as you are endeavouring to read them.
Yes.
Yeah.
At that point, there was no association, correct?
Not to my knowledge, no.
And I know you say...
At that point, there was no association to your knowledge. In that answer, were you thinking of the association as the pre-incorporation entity or the incorporated entity? It's just a question of clarity.
Yes.
Do you follow my query?
Yes. Commissioner, my understanding of my instructions at the time was not that there was a pre-existing unincorporated association, but that there was a desire to form and create an association, and I gave advice on its incorporation.
Which would then become incorporated?
Correct, yes.
Yes.
But you agree with me that on your understanding at the time, as at March 1992, when this advertisement appeared, there was no unincorporated association.
My understanding at the time was that there was no unincorporated association. That's correct.
Now,
just on the advertisement, maybe a trivial matter, but section 5 spoke of the application being in the prescribed manner and form. Wouldn't it ordinarily be the case that the body that administers this act probably has a standard form of advertisement which applicants can look at and tailor to suit their own requirements? In other words, something would say something like this: notice is hereby given that blank, being duly authorised by the above association, intends to apply to the Commissioner of Corporate Affairs on or after blank for the incorporation of blank. The blank is formed for the purpose of blank, and then the applicant just fills in the gaps depending on the circumstances of the case.
that may well be, Commissioner.
It would explain the stilted sort of formalistic language.
It would. It may be in the section 46 talks about a prescription of forms, and it may be the regulations have been passed to that effect. We might see if we can turn those up. Now, just while we're still on the Act, there were also stipulations in the Act about the crafting of rules for the association.
Yes, there are stipulations in the Act that you've got here.
And picking up what the Commissioner was just saying about the advertisement, there's a schedule to the Act which you will find on
Commissioner, just while Mr Stoljo is locating that, I need to sit down, but I'm sure it hasn't escaped Mr Stoljo's recollection. I think Mr Blewett gave some evidence about this matter on the 12th of May 2014, pages 16 and 17 of the transcript, and he gave some evidence about who had drafted the advertisement. If that's of assistance to our learned friend, he nominates Mr Wilson.
Well, this witness is giving her recollection of events, and I'm not sure it assists if...
Just thought if Mr Stoljo was interested in finding out who had actually drafted it, there's been some evidence about it, Commissioner.
Well, he is interested in finding out who drafted it, and he's trying to assemble as much evidence as he can and then survey it all and see what it says.
I have to say that I'll put on record that that interjection was quite inappropriate. Now, Schedule 1, Ms Gillard, is at page 245.
245?
Yes.
Yes.
There's Wilson.
Were these the model rules to which you made reference, or was there some other document?
Mr Stoljo, it's a very long time ago, so I'll try and be as clear as I can given the affluction of time. My recollection is that there was something else provided by the Associations Incorporation people, bureau, register, whatever it was, that assisted people to draft the actual rules that were model rules rather than just the definition of what needed to be in the rules.
Right.
But it is a long time ago, but that's my broad recollection of this area of law is that people were endeavouring to make it simple enough that people could incorporate associations without needing legal advice. So consistent with that, I would have thought that there are more specific model rules available to assist people.
In any event, the Commissioner raised the question as to whether there was some prescribed form in relation to the advertisement, and this was something in the Act that at least provided some guidance in relation to the crafting of rules. Did you look at Schedule 1, do you remember, when you were drafting the rules yourself?
Oh, Mr Stolger, I'm not in a position all of these years later to tell you which pages of a piece of legislation I went to. I received instructions. I obviously did sufficient work to ascertain the law in WA was in the same form as the law in Victoria and went from there.
All right, now the rules themselves are at page 9 behind tab 2.
Oh, page 9 behind tab 2, sorry, I went to tab 9.
And so these are the rules that you put together in the way you describe in the record of interview. And if we work through these, the objects of the association are those set out in paragraph 3. Now, in truth, the object of the association was to raise funds for elections, correct?
The object of the association was, or the purpose of the association was, as I described it earlier, to regularise arrangements between a team of officials who are intending to run in union elections and to enable them to fundraise to support their campaigning.
Well, the reason the association was being set up was to facilitate fundraising by those officials, and in particular to facilitate the creation of an account into which funds so raised could be collected, correct?
That's correct, with the addition of the discussion we had earlier, and when we went to a section of my discussion with Mr Gordon and Mr Shaw, that it also meant people turned their mind to questions like what would happen if there was a division between the team of officials who had been contributors to the election fund.
None of those matters are set out in subsection 1 of paragraph 3 of the rules, are they?
These objects are very broadly drawn, that's true.
Well, it is correct that none of the matters to which you've made reference are set out in paragraph 3, that's right?
I think the matters in paragraph 3 are broadly drawn, and what we've discussed fits beneath them.
Into which subparagraph do you say, or which subparagraph do you say captures the matters that we've discussed?
Oh, for example, Mr Stolger, I'd say subparagraph F.
Is F the only one?
Mr Stolger, the objects are broadly drawn about promotion of change in workplaces, the sort of things that a team of officials might well be promising in a campaign for election.
Why not just say squarely what the object was? Raise funds for elections.
Because in the discussion we've just had, Mr Stolger, I thought that there were other reasons for incorporating an association.
Well, that was one of them.
Yes, one of them, in accordance with supporting a team of officials, or a team, I'm using the terminology officials, which assumes people are already elected. These, in terms of this association, I was dealing with people who were already elected, but more broadly, for such associations, it could be a reform group that's seeking election or a team of officials who are seeking re-election.
But why not just say what the objects were in the paragraph dealing with objects? The object was, as I think we've been discussing, to raise funds for elections, for elections, and to operate an account where those funds could be collected. Why not just say that?
Oh, Mr Stolger, at the time I obviously thought it should be broadly drawn and go to the types of things that might be issues that officials came together to campaign on.
Well, it gives no clear understanding of what the objects of the association in truth are, paragraph 3, that's right.
Well, Mr Stolger, I wouldn't agree with that, and I'd remind you that my instructions about this matter coming from Mr Wilson and Mr Blewett were clear, that they were part of a team that had come together, that had taken over control of the Western Australian branch. At some point in the future they would face an election. They obviously wanted their team to contend in that election and win in that election. So I drew the objects broadly, trying to capture all matters that might be relevant to that.
Mr Stolger, this is a convenient time.
Yes, Commissioner.
Hearing will resume at 10 to 12.